Welcome to today's NEWAP webinar and Legal Services for All, new 2014 Legal Services Corporation Regulations implementing VAWA's 2005's Immigrant Crime Survivors Access to Legal Services. I'm really pleased to be able to, I'm David Lee, and I am helping host today's session, and that you can see that this is presented by the U.S. Department of Justice Office of Violence Against Women in partnership with the National Immigrant Women's Advocacy Project, NEWAP, the National Legal Aid and Defender Association, and the California Coalition Against Sexual Assault. So we're pleased to have all of you joining us from around the country, sharing the weather, and we see people coming from all over the country joining us today. This project was supported by grant number 2013 TAAXK009, awarded by the Office on Violence Against Women, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this publication program exhibit are for those of the authors, not necessarily reflect the views of the Department of Justice, Office of Violence Against Women. So I do want to talk briefly about how to be able to use this technology. The first thing I want people to be able to do is raise your hand. The way you raise your hand is if you look on the far left-hand corner, you'll see my picture, and you'll see a little hand above there. And go ahead, let's see having people raise their hands. Go ahead. This is something that we will be asking for feedback during the presentation. This is an opportunity for us to hear from you, and one of the ways that we'll be able to hear from you, and so it's great to be able to see so many of you doing that. I'm going to lower hands right now. There is a text chat. The text chat appears on the right-hand side of your screen. You would write in here and click on this message to be able to send a message. I see that many of you have already written in, letting us know what your organization is, your city and state, and you shared the weather. It's 71 and breezy in New Orleans and 70 degrees in southern Arizona, but some people are getting a little cooler temperature than that. And so we have the information there. If you want to ask questions or have comments, this is the place to be able to do that. If we are unable to answer all your questions during the web conference, we are committed to being able to doing that and posting on the NEWAP website afterwards, so that information will be available. Similarly, PowerPoint slides. There are slides for all of the presentations. Those and several resources are available on the NEWAP website. I will go ahead and shortly post. I have to get that.
I've got it, David.
Open, but thank you very much. So we will be posting onto here the address, so you can be able the direct link. Leslie wrote down direct link. She just needs to draw. There it is. There's the link. So you can be able to get the information for today's web conference. We'll be asking a few polling questions a little bit later on. And most of you are listening on the computer. You can also call in on the phone and to the number, and I will put that number also into the into the text chat, so you can be able to have that available. And so it's another way that you can be able to join this web conference. If you are having trouble with your audio, I do recommend that you call in. That will sometimes make this easier for you. So with that, you can always send a private text chat by clicking on the private tab to someone privately, or you can send us if you have some technical support, or call iLink Technical Support to join the web conference at 800-799-4510. So with that, I am really pleased to have today's presenters, and I'm going to hand it over to Leslie Orloff, who this is the 8th in our series of webinars that we've been doing, and Leslie Orloff is the director of the National Immigrant Women's Advocacy Project, NEWAP, at American University, Washington College of Law. So Leslie, how are you doing today?
Good afternoon. Thank you, everybody, for joining us. I'm Leslie Orloff. I direct NEWAP at American University, Washington College of Law. We're really happy to have you here today. Just a little background. I'm a lawyer and have been doing work with immigrant crime victim survivors for probably over 30 years now. And I'm very, very excited to have everyone here, because I know I and others working at NUAP in various different iterations of my work back to the days at IUTA have been working on legal services access for battered immigrants since 96 and 97. So this is the culmination of all of that work, and I'm really happy to be here with you today. And I want to introduce B.V. Anver, our policy staff attorney.
Hi, welcome everyone. We're really excited to have you here with us today. We're really excited to go over this new regulation. Just to tell you a little bit about myself, I graduated from American University's Washington College of Law in May of 2013 and have been with NUAP for about 2.5 years now. And I really look forward to your questions, and welcome again.
And then what I'd like to do is also introduce someone who you're going to only see in writing. Rocio Molina will be womaning the text chat today, answering your questions as we go. And it is my great pleasure as well to introduce our other live presenter, Robin Murphy, Chief Counsel at NLADA. Robin?
Yes, hello. I'm very thrilled to be with you and NUAP today. One of my roles, among several at NLADA, is to provide information to the field about LSC regulations. This particular presentation is an area near and dear to my heart because for over a decade, like many of you, I represented victims and survivors of abuse as both a staff attorney and managing attorney at New Haven Legal Assistance and at the Legal Aid Society of the District of Columbia. I have repeatedly witnessed firsthand the tremendous difference legal representation can make to victims and survivors. And while many of you may not be able to save the world, this is an area you can literally save lives in. And short of that, you can make a tremendous difference in the quality of life for so many abused people living in poverty. I'd also add this is a complex area, so as David already said, if you have questions and concerns, please feel free to contact us after the webinar if you have remaining questions. Thank you.
Okay, great. So, Bibi, why don't you share a little bit about some of the resources that are available today?
Sure, absolutely. So again, as Leslie had typed into the chat box, you can find resources for today's webinar as well as additional resources on legal services, public benefits, immigration law, VAWA confidentiality, all kinds of other topics. You can find them on our website. The link for today's materials is nuap.org/go/legal services. That will take you to our section that's dedicated to today's webinar. You will find the PowerPoint. You will find legislative and regulatory history as well as LSC program letters and a brochure that we've written on the regulation, as well as other additional materials related to today's webinar. Our general web library address is nuaplibrary.wcl.american.edu.
Thank you, Bibi. So let's Bibi, let's explore a little bit about who is joining us today. So I'm going to ask for you, I'm going to put into the lower left-hand corner an ABCD. So you look in the lower left-hand corner, there's a little box that says feedback, and let's see who you are. Are you a legal services attorney? Are you another lawyer? Are you another lawyer? Are you a domestic violence or sexual assault survivor advocate, or are you other, which is D? So let's go ahead and share with us. I know that there's still 80-some of you who have not answered yet, but so B, let me share the results with people. We can get live response. We have about half our audience are legal services lawyers. That we've got about 28% of our audience are domestic violence and sexual assault survivor advocates, and then we have a little bit of about a little more than 10% each of other lawyers or other. If you're another, write down what the other is. Don't put the name. So I see some with, if you're another, if you're not a legal services lawyer or another lawyer or a sexual assault or domestic violence advocate, so I see some educators, some state government, a paralegal, mental health, social services, immigration advocate, legal aid attorney. So great. So Bibi, we've got a lot of attorneys in our audience and a lot of people who are very familiar with addressing issues of sexual assault and domestic violence.
Wonderful. Welcome, everyone.
So Leslie, why don't you review today what our learning objectives are?
Oops. Okay. So by the end of today, our goal of this training is to enable you to better navigate the legal services regulations, program letters, and statutes, so that it is to facilitate access for immigrant survivors of domestic violence, sexual assault, human trafficking, and other crimes. For those of you that work in LSC-funded agencies in particular, for those of you that are advocates and others, it's also to understand the range of services that LSC-funded agencies can provide to immigrant survivors under anti-abuse regulations and under immigrant status-based regulations. And then finally, and probably most importantly, is to understand the importance of building collaborations and relationships between LSC-funded programs and other programs in their communities and in their service areas that serve immigrant victims of domestic violence, sexual assault, human trafficking, and other crimes, as well as domestic violence and sexual assault service providers, so that those of us that are serving crime victims can become part of the priority setting process that the local legal services agency uses, and that we'll be talking about towards the end of our conversation today. David, back to you.
Well, thank you, Leslie. I love how someone's already answered this question before I posed it, but I'll put it up there. We want to know from you, have you worked with immigrant survivors who have been successful in receiving help from Legal Service Corporation LCS-funded programs? So go ahead. In the left-hand side, have you been successful in being able to yes or no? And so I still know 120 of you have not voted yet, so let's go ahead, and I might already be sharing the results live, it appears I am. So as you can see, Leslie, and over 80% of those who have voted have been successful. But I do know that there are some that have not been successful. And so, and that we need to be, so if your client was denied help by LCS-funded program, why were they told they couldn't be served? So I'd love to hear from you. Go ahead, write down in the text chat, if your funded was denied, you're part of that 22% who haven't, or those that have but have found others once. Can you find out, can you explain why they were told that they were going to be denied services?
So what we're seeing, David, is one of the responses is that so far is that their client didn't have they'll only be representative if they have a protection order, and that some people are getting turned away. And we've heard this, I know both NLADA and us, we've heard this, that some people are being denied because their immigration status is not determined. And so that's one of the things that should change after this webinar and after some of the materials that we have in the field. What else are you saying, David? I'm
also seeing there's not a sufficient connection between the qualifying violence and the need for service. So, and then some people are new, and no police reports is another one that I've seen.
Okay.
And they're also being asked for more proof of violence, or they are over income.
Yeah, and the over income issue is not one we're going to be able to address, but what we can tell you is that we have a directory, maybe Rosie or Bibi can post, where you can find programs that over income victims of domestic violence, sexual assault, human trafficking can go to get legal advocacy, low bono or low-cost legal services from people that understand this area of the law. Counting abusers' income is another issue that comes up often, and we'll talk about some of the deeming rules. We'll have materials available about those issues later on in the year on another kind of public benefits call. Okay. So essentially, I want to put this into some historical context. Part of the confusion, and I cannot tell you how excited I am to see that almost 80% of you are being successful getting your immigrant survivor clients assistance from legal services agencies. And so hopefully this background will support why you're being successful and help other programs get them the information they need to be able to serve immigrant survivors, ensure that their LSC-funded agencies in their community are able to serve immigrant survivors under anti-abuse regulations. There was a lot of uncertainty about what happened was historically, the ability of legal services funded agencies to represent immigrants generally changed in 1996. There was a set of 1997 regulations that were based on something called the Kennedy Amendment that allowed people to serve immigrant survivors who were married to their perpetrators. But in 2005, VAWA 2005 broadly opened up access to legal services funded agencies with funding from legal services or any other source that agency has to any immigrant victim of domestic violence, sexual assault, human trafficking, or other U visa crime. And that there was a program letter issued in 2006 that implemented that, but because the regulations continued to be the regulations under the old law, there's been a lot of confusion in the field. And essentially we found that about a little over 20% of crime victim survivors were being turned away based on their immigration status, and about 26% were being turned away because programs were not certain about whether or not they could represent immigrant survivors. And this research was done in 2012, so it was 6 years after the program letter came out. And as a result now, and that work and that documentation led to legal services issuing its new regulation and its new policy letter that we'll be discussing today. So for those of you, this is kind of the history of legal services access for immigrant survivors, with the latest program letter coming out last Thursday. The information we're going to be providing you today will be the state of the law as it is today and what programs that get LSC funding can do going forward. Phoebe?
Okay, so the 2014 LSC regulations, these were released in April of 2014. It implements VAWA 2000 and 2005 expansion in protections for immigrant survivors, particularly in access to legal services. The 2014 regulations created two paths by which an immigrant can pursue assistance of legal services from an LSC-funded program. Those two pathways are representation under the anti-abuse laws under 45 CFR section 1626.4 of the regulation, and representation based on immigration status under section 1626.5 of the regulation. So just before we get into the differences between the two pathways, I just wanted to quickly share with you the list of U visa criminal activities. This is to familiarize yourself with this list of activities if you don't already know them, just so that you have an idea of the types of crimes or criminal activities that survivors could then qualify for legal services under the anti-abuse laws. Again, this is in addition to battery or extreme cruelty, which Robin and Leslie will be going into in addition to human trafficking. But I just wanted to quickly show you this list of the U visa crimes. Robin?
Sure. So, why are the new LSC regulations so crucial? Basically, because as Leslie indicated, the eligibility of non-citizen victims and survivors of abuse for legal services expanded significantly. However, the regulations up until this point remained the same, and the LSC used program letters to provide guidance. As evidenced by the NUAP studies referred to by Leslie, the discrepancies in the regulations versus the guidance, plus the fact that this is an area closely monitored by LSC and subject to sanctions, we had a concern that LSC-funded programs would be reluctant to delve into this area. However, thanks to Legal Services Corporation, particularly the Office of Legal Affairs, who have taken the time and effort, including considering the input of the field and stakeholders, to revise 1626, the LSC eligibility regulation for citizens as well as non-citizens, and the revised regulation along with the new program letter 14-3 makes clear that many non-citizens are eligible for LSC services. LSC regulations are also critical because so many non-citizens or victims or survivors of abuse often have multiple needs for representation. So often, as many of you know, victims will remain or return to abusive situations if they have no place to live or are hungry or don't have access to other necessities. Custody can also be a great need because an abuser often will use a child as a means to continue to control the victim. Third, access is key to providing services to victims and survivors. They are under incredible stress and anxiety. It's very difficult for anyone to navigate the legal systems, let alone somebody in poverty, but particularly if your adverse party is the abuser. And these services are even more crucial for non-citizens who are exceptionally vulnerable to being exploited because of their status and other barriers such as language. The current anti-abuse laws, and there's two basically tracks, the current anti-abuse laws allow representation for many categories of abuse victims as listed here, without regard to people's immigration status, domestic violence, child abuse, elder abuse, sexual assault, human trafficking, and other visa activity, those crimes listed by BB previously. And representation is available whether or not the survivor has filed for or plans to file for VAWA-related or any other forms of immigration relief. The two paths, anti-abuse statutes and legal immigration status-based eligibility. Basically, the regs outline two paths. One is based on the person's status as the victim of abuse, and there is not, it's not relevant as to their immigration status. It's whether they qualify under the anti-abuse regs for representation. There is an advisory opinion 2009-1008, which makes clear that evidence of abuse, not the immigration status, is the basis for eligibility, as do the new laws. There's also a second path, eligibility for LSC-funded legal assistance based on a person's immigration status. This list that we have given you today is not exclusive. It covers some of the immigration status areas that would make people eligible for LSC services, and also includes people who are not subject to eligibility immigration status. There is a program letter which we've included in the materials which lists numerous examples, and this is from LSC, but is not exclusive of people who would be and what evidence is needed to show their eligibility either under the anti-abuse statute or under immigration status.
So what happens is that the first way in for many crime victim survivors is going to be access to legal services under the anti-abuse provisions. So when somebody first walks in the door, they may have a bruise, or they may tell you a credible story about the abuse they've suffered. They don't have to have a police report or a protection order, but that they have to have, some evidence of abuse. It might be a photograph, it might be their own testimony, it could be any number of things. But they're eligible for, when you come in under the anti-abuse regulations, you're eligible initially to receive representation on issues related to the abuse. That person who comes in and has a limitation initially on the kinds of services they can get, which are related to the abuse, and we'll be talking about that in a minute, and there's a broad range of things that could be related to the abuse, without regard to whether or not someone is actually pursuing immigration status. Immigration status isn't a prerequisite to representation, let's say in a custody case, if that's what the person is seeking help with initially. But that there are immigrant survivors who start off on this anti-abuse track who become, if they pursue immigration relief, become eligible eventually to be represented under the immigrant status track of representation, point 5 we were talking about a bit ago. And that representation track has no subject matter limitations and no connection to the abuse requirement. So for example, a battered immigrant comes in. When she walks in the door, all she knows about is a protection order. She learns from her legal services lawyer that takes her protection order case that she's eligible for a VAWA self-petition. Under the anti-abuse reg, the lawyer can help prepare the VAWA self-petition, and once the VAWA self-petition is filed, the filing of the I-360, which is the name of the VAWA self-petition, you will see is one of the evidence of the documentation examples listed on the May 19, 2014 LSC chart of the kinds of evidence you can show that you're eligible for representation under the immigration status track. So that's an example of how you can shift from one to the other. Under certain circumstances, if the survivor also has a citizen family member connection as required by the law. So it's not automatic, but there's certain subsets that can shift from one to the other. David?
Leslie, there was a question of, Molly was asking, can a DACA recipient be eligible for LCS services?
What happens is it's LSC, and Deferred Action for Childhood Arrivals would only be eligible if they are victims of if they can qualify under the anti-abuse regulations as victims of domestic violence, sexual assault, human trafficking, battery, extreme cruelty, or one of the other listed crimes. So if they're not survivors, they are not eligible, as I understand it. Robin, is that your understanding as well?
That's correct. But then if helping the person with the DACA petition would help get the person out of it was considered related services to the abuse, then they could help them with the DACA petition, but it wouldn't be the basis for LSC eligibility.
Correct. Okay.
Okay. Thank you. So let's pose a question, I think, for our audience here, and I'm also putting it into the text chat. Should have gone into the text chat.
I'll do it, David. What are the examples?
Oh, my text chat just disappeared on me. So here, so I will hopefully be able to get it back. What are some examples of when an immigrant who is eligible to access legal services under anti-abuse statutes could then transition to eligibility? So we want to get examples of when an immigrant who is eligible to access legal services under anti-abuse statutes could transition to eligibility under immigration statuses.
So are there people in the, can you type in your responses?
So someone gave homeless DV victim. Someone wrote petition filed and qualifying relative. Someone wrote once their adjustment of status application was granted.
Mm-hmm. Okay, so
immediately after submission of U visa adjustment or VAWA adjustment.
Okay, so these are some examples. So we've got, you file the application for the adjustment of status. You have a victim who files an I-360 who has a U.S. citizen child. A homeless DV victim would not qualify. They wouldn't qualify under the immigration status. They'd only qualify under anti-abuse.
Okay, and
the last one, again, they would qualify under anti-abuse, but not to shift to immigration status. Generally speaking, the shift occurs when they've got a petition, an immigration case in the system, and they have a qualifying relative. Okay. So to pick up again for a second as to the categories of related legal assistance, but before I want to do that, what I want to say, there's one question that came up that I want to address, which is, if you have a victim, and we'll be getting to this in a few minutes, but in a few minutes, Robin will be talking about where the abuse happened, whether it's in the United States or out of the United States. But generally speaking, the program letter that was issued Thursday confirms that the abuse could have happened in or outside of the United States, and we'll talk about that in a few minutes. But I'm going to talk first about related to the abuse. There is a broad range of kinds of services that could be related to the abuse. As in the example that Robin gave you around the DACA child, someone could come in and need a protection order, which is clearly directly related to abuse. It might be a custody case. It might be a divorce case in which you're exchanging property because of the domestic violence. She's seeking a disproportionate share. In sexual assault cases, there's a whole range of privacy, safety, confidentiality issues that the victim may need assistance with that the LSC-funded program could assist her with. In cases of assault or sexual assault, sexual harassment, assault or sexual assault in the workplace, you might have workplace-related remedies that be involved. There's a whole range of public benefits that somebody might need to escape the abuse, to leave, whether you're talking about an abusive domestic violence situation or you're talking about abusive employer, or it might be a school setting. It might be somebody who's been raped and needs to, switch institutions or something like that. Healthcare access, help from police and prosecutors, employment laws, education laws, especially now that the Clery Act is passed. There may be Clery Act involvement that that the victim needs assistance with because she's a survivor of sexual assault or domestic violence or dating violence, whether on campus or whether she's a student and she's been involved, she needs assistance. Language access will be a big issue, and sometimes it's not just language access to the LSC-funded program. That's not usually, hopefully, the issue, but it may be language access to the public benefits agency or a hospital or local police or prosecutors. And there may be, for disabled victims, help with Americans with Disability Act protections, landlord-tenant cases, et cetera, crime victim services. So, some of the examples of survivors, the most common examples of the way that you'll see survivors switch paths will be U visa victim holders who file for lawful permanent residency, and VAWA self-petitioners who have a U.S. citizen spouse or a over 21-year-old U.S. citizen child or a U.S. citizen child generally. Correct, Robin?
Correct. I'm sorry, I was muted.
Yes, I just want to make sure I got that one right. So that there are various different ways that they can move. So a very common one is the DV survivor, as I talked to, starts under anti-abuse regulations, files an immigration case, then becomes eligible for lawful permanent residency under the T visa or the U visa and actually files, or the family member related ones. And that the difference is, okay, that's good.
Yeah. So there are differences in representation, whether you are whether the survivor is accessing legal services based on anti-abuse or under immigration status eligibility. If they are accessing representation under the anti-abuse regulations, they can only access representation that is directly related to the abuse. However, if they are eligible for legal services based on immigration status, any form of legal assistance offered by the LSC-funded agency is available to that survivor. So what does that look like visually? If you see it based on the eligibility under anti-abuse statutes, it's limited. So let's just take a look at this. We'll highlight it so we can really see what that means. Anti-abuse statute limited to services related to the abuse. However, if the survivor was eligible based on legal immigration status, then their legal services are unrestricted. They have access to a wide range of services that are offered by the LSC-funded agency.
Robin?
Yep. So, what's the definition of related to abuse under the anti-abuse statutes? They are legal services needed to escape from the abusive situation, ameliorate the current effects of the abuse, or protect against future abuse, so long as the recipient can show the necessary connection of the representation to the abuse. And this is not, the preamble that LSC issued with this regulation indicates that the examples given in the regulation are not exclusive, that basically if it's necessary and related to providing relief from the abusive situation, that would be a means of qualifying you for LSC services. So, David?
So let's go pose another question, and I'm going to put that into the text chat also. is what type of legal services fall under the related to abuse standard. So go ahead and write it into your text chat. What type of legal services fall under the related to abuse standard? So, and actually there was a question that I got privately, was that someone was asking for an expansive interpretation of what are services related to abuse. So I think we're going to get to that same question here. So go ahead, and I'm not seeing a lot of people here. There's a little, yes, there is. People have been coming in with quite a few of child custody, preservation of housing, child protective orders, custody assistance, a lot of assistance assistance with unlawful detainer to help secure housing, so a lot of housing ones I'm seeing. And housing, custody, protective orders seem to be the theme that I am seeing. Victim crime compensation, child support, custody, divorce. Restitution, someone asks the question. So those are some of the pieces that I'm seeing, Robin, of how people are responding to this.
And one of the things I saw was almost anything if it's related to the abuse, and I think that really covers it. As I indicated in the beginning, often there's economic reasons that will either keep a victim or survivor within a relationship or cause them to return to an abusive situation. And so access to benefits or any financial help, which would include housing relief, relief with an employer so that the person can remain employed or obtain employment, discrimination issues. There's really a broad range of issues. The big question is the connection to the abuse.
So thank you. So you were providing that more expansive definition of abuse. There was a question here that someone was confused, but we'll come back to the qualifying family member, I think, a little later. That's a little different.
I'll ask you a question, Robin. What about civil tort litigation? Is that covered, or is that something that an agency would do?
I don't think that's something that generally a legal services program would do. That falls in another category in terms of that we would need to deal with separately.
Right, and okay, good. Thank you.
Okay, so Robin, why don't we go ahead and talk about a little bit more about the eligibility under anti-abuse statutes that are available.
As we said, it also doesn't require that the person seek relief on an immigration case to receive relief under legal services. So the person does not have to be looking for any immigration relief at all, or they could be represented by another entity for immigration relief as long as they qualify under the regs, under the anti-abuse statutes, and the matter that you're representing or the case that you're representing, the person is connected to the abuse that qualifies them.
Okay. Leslie?
So if your client, again, to reiterate, what is the most important point about a lot of this is, A, that it's broad. What can be done is what your agency provides that can be related to the abuse and related to that individual overcoming the effects of the abuse in their life. But there's also the role that LSE-funded agencies and advocates that work with them can play in helping clients, A, screen early to determine whether or not somebody qualifies for immigration relief, because even if they're coming for housing, benefits, and child custody, if you screen them and you determine that they're eligible for immigration relief, there's a lot of reasons, and we have lots of really good materials and other webinars on this for safety planning reasons, that you may want to screen them and help them apply for immigration relief if the victim is eligible and wants to apply, because not only are there safety protections from the Department of Homeland Security that are enhanced and better available to her to protect her from deportation once she files an immigration case, but she is on this path potentially to being able to switch tracks if she has a qualifying relative and she's a VAWA self-petitioner, or switch tracks because she's a U or T visa pursuing lawful permanent residency based on that. So screening can lead somebody to be able to switch tracks to the full representation sooner.
Thank you. Let's pose a question to our audience. Can survivors receive legal service assistance if they are not currently present in the United States? So it's a yes or no. So go to the left-hand side. Can survivors receive legal assistance if they are not currently present in the United States? So, Bibi, I'm noticing people are responding. We still have about a lot of people who haven't responded, but I'll share the results. So far, we're at about 50-50. There's not consensus in our audience, I'm noticing on this. Bibi?
Hey, well, you know what? We will reach consensus by the end of today's webinar.
Great. Why don't we move on to Bibi? So,
presence. These are the categories as broken down in the regulations. And you'll notice that human trafficking as defined by VAWA 2005 and severe form of human trafficking as defined in the TVPA, or the Trafficking Victims Protection Act, any survivor that is trying to access legal services by being eligible under the anti-abuse statutes, under these two definitions, their presence is required at the time they apply for access to legal services. You'll notice that human trafficking as a U visa crime does not require presence at the time that the survivor applies for legal services. The same goes for domestic violence, sexual assault, the U visa qualifying crimes that I showed you earlier, and the battering or extreme cruelty. So again, presence is required for the first two, human trafficking as defined by VAWA 2005, and the severe form of human trafficking under the Trafficking Victims Protection Act.
Robin?
So Leslie. Oh, I'm sorry. Robin. I was.
Either of us is fine.
You take it, Robin.
One thing I wanted to also mention in terms of the severe forms of human trafficking, which is important to note, is that the legal assistance is not limited to related legal assistance, that can entail a full component of legal assistance. And that's one exception under the anti-abuse to that qualification. Now, under VAWA 2005, and this goes to our poll, without regard to where the victimization occurred, inside or outside of the U.S., you can include domestic violence cases, sexual assault cases, U visas cases, including trafficking. As to severe forms of human trafficking, the person's physical presence is required in the United States. Also under VAWA 2005 LLC, trafficking physical presence is required. However, once the representation is established where physical presence is required, then if there's a temporary absence after the representation has begun, they may be able to still remain qualified for services from legal services.
And what's really, I think, important to note here, I just want to make a note on the various, there's several different kinds of trafficking here. When we say VAWA 2005 LSC trafficking, that is a trafficking victim who's present in the United States, who might be somebody who's a victim of a severe form of trafficking or a victim of a U visa-related trafficking, but they're not offering the helpfulness or cooperation that would be required to apply for the U visa or the T visa, or they're defined as trafficking victims under the state laws. So it's a catch-all provision that captures trafficking victims that would be left out otherwise. So the next thing we want to talk about is, you've heard us say, you saw on the chart Bibi discussed a few minutes ago, that she used the term battering or extreme cruelty from and in addition to domestic violence. And the Legal Services Rule adopted the broad definition of domestic violence that has been used by the Department of Homeland Security for the VAWA self-petitioning regulations, for the battered spouse regulations, and in fact, LSC adopted this definition of legal services consistent with then INS back in the Kennedy Amendments in '97. So in that case, it's elements of battering or extreme cruelty and or domestic violence. It certainly covers the kinds of domestic violence that would be covered under your state protection order statutes or your state criminal statutes, but that also includes forms of extreme cruelty that would not be included in your state protection order statutes, except for in some of the more progressive protection order states. So battered or subject to extreme cruelty includes, but is not being limited to, being a victim, and this is generally the DHS definition, of any act or threatened act of violence, including forcible detention, that results or threatens to result in physical or mental injury, psychological or sexual abuse or exploitation, including rape, molestation, and incest of the victims and minor. And the DHS definition is also very clear that it includes non-physically abusive actions and parts of the pattern of abuse in the relationship that may not be in and of themselves criminal, but might be part of the pattern of abuse itself. And that this definition applies broadly to all kinds of adults. It applies to elder abuse victims. It applies to many children. So that battering extreme cruelty, for example, would include child abuse. Now, what's interesting, a point I wanted to make is that some of you, can you raise your hands? I have a question. Raise your hands if you are an LSC-funded program that also receives Office of Violence Against Women OVW funding. You see, the raise your hands is on the top left. I see, okay, we're waiting a few minutes. There's at least, looks like about close to 30 or
we got over 30, Leslie.
Okay. So there's a number 33 of those programs on the call that have both sources of funding. Now, what's important to understand, let's take children for a second. Under your LAV funding, your LAV funding has to go to representing people over age 13, and has to go does not include child abuse only, when the only thing that somebody's experienced is child abuse. It includes domestic violence, dating violence, stalking, and sexual assault. That's what your LAV funding would cover, legal assistance for victims. You're on the LSC side, though, your LSC funding can cover the full range of battering and extreme cruelty and can help child abuse victims that wouldn't be covered under your LAV funding. And it can also include children who might be victims of incest, for example, that are under the age of 13. Robin?
Yep, and it would also include, we've gotten a lot of questions from the field, and I think LSC also has, about unaccompanied minors who are entering the U.S., and currently there's large numbers, or have been large numbers, of unaccompanied minors entering from Central America. That population can certainly be represented by LSC programs, but their status as an unaccompanied minor is not what qualifies them for representation. They would still have to qualify under one of the prongs of the anti-abuse eligibility requirements and fall within that. And also the representation would also have to fulfill the second prong, which is that the legal services would be related to the abuse. So that would be for the unaccompanied minors.
Yeah, there was a question, how about asylum cases for DV victims? Is that permissible?
I'll take that. This is Leslie. If, in fact, when we were talking about the broad range of related to the abuse categories, if in somebody, let's say a victim of domestic violence who's being represented under anti-abuse laws here for a representation, if she has a gender-based asylum case, that would qualify because it's one of the forms of related legal assistance, just as a VAWA self-petition or a U visa would be. If, on the other hand, somebody's applying based on immigration status and it's not related to the abuse, they're not on the anti-abuse track, then, as I understand it, and Robin confirmed, that asylum representation isn't authorized.
That's correct, Leslie. It has to fall within immigration status. Once a person has been granted asylum, they would qualify, but the process for obtaining that would not be a grounds for LSC eligibility. It could be, as you said, something that could be provided if the person was eligible based on the regulation, but not in and of itself a means for eligibility.
Right. So based on the anti-abuse track of representation, exactly. So I'm going to go through now and just kind of reiterate, because this human trafficking part is a somewhat complex part of this regulation and the policies, and I just want to make it clear that essentially, again, I reiterate, that trafficking victims have 3 pathways to representation. The pathway with no restrictions on what's offered is somebody who's a victim of a severe form of human trafficking, who's applying for continued presence or has got continued presence or a T visa, bona fide case, which would give them access under Section 107 of the Trafficking Victims Protection Act to legal services. And for those of you that have been, and I know there are a lot of you, I recognize your name, legal services lawyers for a very long time, it's important to note that this regulation doesn't narrow in any way the eligibility that victims of severe form of human trafficking had for LSC representation. It just creates additional pathways that trafficking victims have to representation, either as U visa victims or, as I said earlier, as VAWA 2005 LSC trafficking victims, which is that category that covers your state trafficking laws to the extent that they're different from the federal standards, etc. And that for severe forms of human trafficking, the LSC is also, under the TVPA, authorized to represent victims, their trafficking survivors' family members who've been granted derivative T visa status, and LSC-funded agencies can now assist children and family members of immigrant survivors of human trafficking. And we have a flow chart that we created for you because this is very complex, as you can see. And we tried to make this simple. The way this flow chart kind of articulates how we think it might, or at least NUAP's recommendations about how you might think of whether somebody's eligible. People can come in, this is for the anti-abuse provisions only. So some victims may come to an LSC-funded agency that are lawful permanent residents or battered or conditional permanent residents or have some kind of status that's already on the list. For those victims, the LSC-funded agency can represent them in anything they want, including all the abuse-related issues, even though they're coming in on the immigration track as opposed to the anti-abuse track. So we don't want to say that you only get abuse representation, you get it on both tracks. It just depends on whether there's a connection required or not. So with a domestic violence victim, what you want to do is look and see whether somebody suffered battery, extreme cruelty, or sexual assault or domestic violence as defined by VAWA 2005 first. If the answer is yes, what you want to do is figure out if they've applied for or have a case like the I-360, I-130, the VAWA self-petition, or there's a various number on the list, the chart that we provided you from LSC. There's all kinds of documentation that they might have that would indicate that they're eligible for immigration-related representation. If they are, then they go to the left on yes, and they get immigration status representation without any restrictions. Am I getting this right? Yeah. And so if they are, they get immigration, they can go to the unrestricted track if they're married to or the parent of or is the unmarried child of someone who's a U.S. citizen. So you have to move from anti-abuse to immigrant status representation. You have to have, that's the family connection you need to have. If somebody isn't a victim of battery, extreme cruelty, or sexual assault, then you go no, and you go through the U visa list of crimes to figure out if they're qualified, and then go through the same analysis to figure out if they're getting related legal assistance under the anti-abuse, or whether they have the kind of relationship and pending case they need to qualify for full representation. After you can go to T visa, continued presence, And if you don't have either the domestic violence, if you don't have domestic violence sexual assault, you don't have a U visa, you don't have a T visa or continued presence, then only then do you go to kind of that trafficking, VAWA 2005 trafficking, which would be somebody generally, as I said, who is not willing to make a police report or cooperate in a U or a T. And so what happens is, and then if in fact, and then if you follow this track, you'll have some people who won't be, let's take an unaccompanied minor who comes over the border, is seeking help from an LSC-funded agency, but has no abuse history. That is an example of someone that may not qualify under the anti-abuse regulations, and they're not going to qualify under the immigration status regulations, so they're not LSC eligible. So this chart walks you through the kind of yes, no, and how to kind of figure out what people qualify for. And let me just say, this chart is a great example of why Robin at NLADA and me and Bibi and Rocio at NUAP are here to answer all your technical assistance questions and help you go, have particular case-specific answers for you to help you as you begin to navigate this, whether you're an advocate, an attorney that works for legal services, and an attorney that doesn't, or any other kind of a caseworker.
Okay, great. So, additional provisions in the 2014 LSC regulations. In addition to creating these two pathways that Robin and Leslie have gone into great detail about, additional provisions were also in the 2014 regulation. They are ones that confirm that unmarried survivors are eligible for LSC-funded legal services. There's also eligibility for immigrant survivors in same-sex marriages, and there were changes made in the record-keeping and intake procedures to facilitate access to representation under the anti-abuse statutes. And Leslie, I believe that included that police reports are no longer needed. Is that correct?
Correct.
Great.
And they wouldn't be needed. I mean, it's anything you can use, and Robin, you can help us with this a little bit, but anything you can use to prove that you've been a victim of domestic violence, sexual assault, human trafficking. There's a broad range of ways, if you go back to the definition of battery or extreme cruelty, that could be used to create that eligibility. Anything you want to add on record keeping, or?
Well, I would just once again point people to the program letter of 14.2, which also has the chart on eligibility, and it contains a list of different things that one could use to show evidence of the person being a victim of abuse, but it's not an exclusive list, so there may be other things that people come up with. I mean, they need to be credible, but it's not exclusive. You can come up with anything. You don't have to have a particular piece or particular document as long as it's credible evidence that a person has been a victim of abuse.
And that approach is really consistent with what's happened throughout immigration law. Under the DHS regulations, there's an any credible evidence standard. That same standard is used in TANF and has been used in other places regarding issues regarding abuse generally. And we have lots of materials on our web library that show you different ways using any credible evidence you can prove abuse, and we again can provide technical assistance on that as well.
Great. And okay, so just to quickly review one of the new provisions, which was eligibility for immigrant survivors in same-sex marriages. After the U.S. Supreme Court decision in U.S. v. Windsor, which was in June 26, 2013, the decision that struck down a portion of the Defense of Marriage Act, otherwise known as DOMA, the holding by the Supreme Court was that as a matter of federal law, same-sex marriages are now recognized. And so DHS, under that ruling, now has opened up availability of VAWA self-petitioning to survivors in same-sex marriages. And so under the new regulations, same-sex marriage domestic violence survivors are now also eligible to receive LSC-funded representation Again, can either be under the immigration status eligibility or the anti-abuse statutes.
So here is a question for people that we'd really like to hear from. Leslie and I have talked about how does a program handle intake? Because one of the problems I can see is for people who are U.S. citizens and you start asking them, are they a victim of abuse as the first questions out of the box? They could be offended, wonder why you're asking them that, particularly if they're coming in for relief that has nothing to do with any kind of abuse. On the other hand, if you have somebody who's not documented and the first thing you're asking them is, are you a U.S. citizen, that could be very off-putting and chill the applicant and cause them to leave the office. So basically, this slide asks for contributions from the field, and we're looking for best practices. How do people handle intake? How do they deal with getting the information out without offending somebody or chilling them from wanting to apply for legal services? And I'll turn it over to David to monitor this.
Okay, I am trying to find my public.
Actually, David, while you're doing that, I have a question. Maybe you can raise your hands again. How many of you work for LSC-funded agencies that have begun to work or have policy, intake procedures in place that are screening, that are asking people about abuse already? Oh, good. Look at all those numbers, Robin.
All right. I just lost my access to the webinar.
Okay, we're up at around, it's looking like we're almost to 30. 28 agencies are on the call, 29?
29, up, 28, someone's deciding back and forth. 30, we hit 30.
Good. So
great.
That's great because it's an so for some of you that have those practices, can you share some of the approaches you're taking? What changes, the kinds of procedures your agencies are considering making or have made?
Okay, and we are repeating the question, as many people have requested. What changes in procedures would be helpful in facilitating immigrant access under the new LCS regulations? So what changes do you see that you think that would help, things that we should be asking in an intake process that might help facilitate this? So I put that both in the text chat and it's also on the screen. So Robin, let's see. I see there's other questions coming in. We're going to have plenty of time for questions. So we will get to all your questions very shortly. We just have a few more slides, then we'll come back to those questions. But I'd love to hear from people what changes in the intake process. And so someone suggested for immigration intakes, the last question is, what is your immigration status? Someone suggested updated intake forms, training screeners and frontline staffers. Explain why we ask what we ask and get all the immigration-related documents up front if there's any. Asking about abuse last. There's interesting questions about when you ask for things. Ask for it last is one that I've seen. To identify other categories before you get to those questions. Top-down training for all judges, law enforcement, and DAs on the 1918B certification signing. Questions about abuse should be phrased in different ways. Person doing intake should speak language of immigrant to the extent possible. Language line is not great for these discussions. The question of are you a U.S. citizen or resident should be asked at the end of the intake. Yes, we do have the PowerPoint. We'll post that available. We'll paste that soon. Have checkboxes in the intake forms. Ask if you're a survivor of domestic violence. Our friend staff also speak English and Spanish. So there's language still is a barrier. Yes, so those are some of the things I'm hearing.
So it sounds like, Robin, people kind of landed on the debate and the themes that we've been talking about, which is, because some people are going to be eligible for full representation based on immigration status, the issue is which comes first, whether you go immigration status or abuse first. And it's really, I think there's, personally, I think possibly because abuse is a broader range of people that you ask abuse first. The issue, though, is for some people, like if somebody's coming in, I think an example is they're coming in for some problem with housing or a custody problem. And they may or may not be eligible, they may be or not be victims of abuse. There are advantages in the screening intake, even if somebody is eligible under the regular system, because they're an immigrant, to find out about domestic violence, because that information may make them eligible for additional VAWA protections related to housing. It may strengthen substantially their custody case. So we've been, and I know OVW and others through the ABA have been involved in trying to train lawyers more generally to be asking abuse cases questions, even when it's not about abuse initially, why they presented or what they came to the agency. On the other hand, on the other side of it, you have to there are some people that might be scared away by the abuse questions, just as there's some people who might be scared away by the immigration questions, and you have to kind of balance it. Robin, your thoughts?
Robin, is your phone on mute? Hi, Robin, we're not hearing you.
Hello?
Yes.
Hi, Robin.
Hi. No, I think Leslie has covered it well. It is a balancing act. I think, if the case has been referred by a domestic violence agency, there may be some, context cues so that people know to ask about abuse, but it really, it's a challenge as to how the best way is to approach each individual.
Mm-hmm. And I would just say that if you have a sense that somebody may be an immigrant and that asking the immigration cases first is going to scare them away, then you may want to find your way. And I think somebody mentioned it. It was very good. If you look at how healthcare professionals, for example, ask about domestic violence, has somebody hurt you recently? I mean, there's some very ways without using the phrase domestic violence, because in many cultures that doesn't translate into anything that makes any sense. It's particularly if you're using an interpreter or a language line, you have to understand that some of that stuff will get translated literally. So sometimes you want to ask the more generic questions. Are you afraid of anyone? Has anybody hurt you? Are you worried that something's going to happen to you? And try to feel your way through it that way. And this is where I think we're going to be talking in a few minutes about collaborations. And I will say as a lawyer that in my experience, most of what I've learned that's really good about this issue I've learned from victim advocates. Is that the victim advocates, our victim advocates, allies, and partners can be really helpful. That's why in a minute we're going to be talking about collaborations. One of the advantages for a legal services agency creating relationships with victim advocates that serve immigrant survivors and other survivors can be, some help with thinking about the community they're serving and how to ask some of these kinds of questions, because victim advocates whether they're working in an immigrant community-based organization or a shelter or a rape crisis center, struggle with these issues all the time in terms of how to get people willing to talk to you about the domestic violence. And there's a lot of work on that, and we have some good screening training materials as well, but the victim advocacy community can be very, very helpful in this. So, David, can you change to the next slide? I'm having trouble.
Okay. It's you, Leslie, I believe.
There we go. So that brings us to kind of the last really substantive section of this presentation. And I have to tell you that I am personally extremely excited about the fact that we now have statutory authority to represent victims, that LSC has done such great sets of program letters and regulations. And so what does that mean for all of us? And it means that, and Robin's going to explain to you a bit more in a few minutes, but that we now, as movement of people, those of us that are advocates and attorneys who've been working for our careers and are working now with victims of domestic violence and sexual assault and human trafficking and other crimes. It's an opportunity to create a dialogue with LSC-funded programs I'm having slide change problems again. It's an opportunity to create relationships with local programs that are the LSC programs that can really make a difference in which survivors, which groups of victims, and how many victims get served by your legal services funded agency. So, David?
So let's ask this question here for yes or no, and I will put the little box in here. If you are with a non-LCS agency, do you have a relationship with the LCS-funded agency in your service area? And I see a question here that Patty raises of having many clients but having difficulty finding legal services that will coordinate in assisting them. So I'd like to hear if you are not with an LCS agency, go ahead and let us know if you have a relationship with them, and I'll share the results. What we see here, Leslie, is about three-quarters do have a relationship, but there's still 1/4 of those who do not have a relationship. And I think, Leslie, one of the first things you're going to suggest is that's a relationship that's important to be able to help create.
Exactly. So, again, I'm very excited to see that almost hundreds of you are already doing this, and that should be encouraging for everyone else. So Robin will tell you more about it, but every state has legal services LSC-funded programs in their state that is an opportunity for your agencies, if you're not LSC-funded, to coordinate with and collaborate with around representation of victims. And so what I'd like to do next, David blocked it. Okay, David.
Oh, I'm sorry. Here, we're going to go here. We have some questions. Yeah, we're going to ask some questions for people to. I'm going to actually do this to raise hands. So Leslie, if you're with an LCS agency, for all of you here, which
LSC,
of the following
David.
agencies? LSC, I'm sorry. And someone was asking what that is, so Legal Service Corporation, usually called Legal Aid, as Rocio points out. If you are an LCS agency, which of the following agencies do you have an existing relationship with? So go ahead and raise your hand if it's just domestic violence programs. So I'm actually going to lower everyone. I'm going to lower hands.
Funded agencies have relationships with domestic violence programs in your area?
So we're seeing this is exceeding 30. We're going to 40. We're over 40. So in about half over, we're getting close to 50. So a lot of people have domestic violence. I'm going to lower hands, and let's ask how many of you have relationships with sexual assault programs? And I'm hoping it's going to be as many, but we will see. And it looks like it is a very similar number. In fact, even more, slightly more, have relationships with sexual violence. I'm going to lower all your hands again. How many of you have existing relationships with immigrant community-based agencies? And so, Leslie, I'm noticing that our numbers are have been similar for all of these, and so it's about the same number of people, getting close to 50 here. And I'm going to lower the hands one more time. How many of you work with trafficking service programs? How many of you have a relationship with trafficking service? And once again, Leslie, a little, okay, numbers are getting to 30. So it looks like a little bit fewer that have trafficking. So we see domestic violence and sexual assault and immigration have been the most, immigration community-based organizations there, and a little bit less in trafficking programs. So Leslie, really interesting to see where the existing relationships are, but also speaks to where the possibilities are where we can move.
Well, that's great. One of the reasons I love having you all participate is we can really see what's happening. And so I'm really excited to see how many of you are already working with your domestic violence sexual assault, immigrant community-based, and trafficking victims organizations. And that for the rest of you that maybe are just might be starting with these new statutes and regulations to begin doing that outreach, you can see how many people are already doing it and how valuable it must be. So, you know, in an ideal world, what we're looking for is making sure that services and programs serving survivors, domestic violence and sexual assault coalitions, survivors, victim advocates, and community-based organizations that work with victims and that work with immigrants find out who your LSC-funded program is in your community and begin working with them. It's a really incredible opportunity. And why is this collaboration so important? How can these relationships help all of us in our work working with immigrant survivors? First of all, and Robin will explain this in more detail, it's an opportunity for the non-LSC funded agencies, whether you're a lawyer, victim advocate program, immigrant rights group, to become part of the consultative process as the LSC funded agency sets their priorities for the kinds of cases they're going to handle. And Robin, again, will explain that in a minute. It's an opportunity the LSC programs can collaborate with and rely upon community-based programs for outreach and education. Some of the domestic violence and sexual assault programs, some of the immigrant rights programs can also assist the LSC-funded programs in outreach and education to the community about their programs. Victim advocates play an excellent role in safety planning, and if you're working in an LSC-funded agency that may not have been that involved in the past in working with survivors of abuse, your victim advocacy programs and your other legal lawyer programs that have been around and doing work with survivors could be an excellent resource for that. Case management can be something that's shared. There might be a social worker at a local shelter, rape crisis center, that will help coordinate with you the work and provide supportive services for your client when you're doing the legal services case. The other thing is that we, and Rocio, if you could post the U-Visa policy and practices guidance that we've developed with Muskie, one of the things that we found is that victim advocacy programs that have a long-time history of working with law enforcement around domestic violence and sexual assault cases have a great capacity and really good experience that and end up being able to be very capable at getting U-Visa certification, sometimes when those of us lawyers have been less effective in the past. And so that collaboration can really, really help on the U-Visa cases, and Rocio will post the link to that material. Agencies, the domestic violence, sexual assault, immigrant service agencies may have counseling and therapy programs that can assist clients of LSC-funded programs. These agencies may be able to work together with LSC programs to provide trauma-informed services, and we have a webinar and a series of materials on best practices for trauma-informed services for immigrant survivors, and the role that a trauma-informed approach to gathering the victim's story can play in enhancing the quality of the immigration case, but also helping the client heal. Collaboration can result in court accompaniment by non-lawyer victim advocates, can help the client better access services writ large in the community, can greatly improve language access. When you look at the courts and whether courts provide, how much language access courts provide, there's a direct connection, according to the National Center for State Courts, between relationships that the courts have with victim agencies serving immigrants and immigrant victims and language access in the courts. And there's a lot of really good advocacy that these collaborations can work to develop so that victims have access to police, prosecutors, courts, benefits granting agencies, healthcare, language access to them. And then they can always help, these collaborations really do help in preparing the affidavits and gathering the evidence for victims' VAWA, T, and U-Visa applications. And there are many programs around the country where the advocates actually take the lead on working on gathering the information for the affidavits and share it with the legal services attorneys. And when that happens, the legal services attorney might be able to represent 2 victims in the time it might have taken them, 2 or 3 in the time it might have taken them if they were doing all of this work without the assistance of victim advocates themselves. Robin, over to you.
Okay. So LSC has a regulation which requires programs to annually set their priorities for delivering services, and it's 45 CFR 1620, and it basically requires programs, their board of directors, to set a process for how that program is going to set their priorities. Then it prescribes how they're supposed to determine priorities, which includes an effective appraisal of needs of eligible clients in the geographic service area. So this is a way to both get the input of your community, and if you're a community member, to ask for input into LSC's priorities. And there's a non-exclusive list of other factors that the programs are supposed to consider. But basically, attorneys are limited to providing service within these priorities unless there's an emergency. And there's no prescription by LSC as to what the priorities should be, just that there has to be a process for setting them, and then once they're set, that people stay within those parameters, unless I said if there's an emergency, and if there's repeated representation under emergency, that would be a clue for the program to reconsider their priorities and whether they want to add that area. So in a nutshell, make sure your program has procedures for developing priorities, that the process appraises the needs of eligible clients in your areas, and that they're followed except for emergencies. There's a specific list of what's considered an emergency, and in the recent program letter, LSC does emphasize the need to look at the priorities. But it's
Robin,
really a positive opportunity for you to really solicit input from the community.
Robin, this is Leslie. What time of year or how frequently are the programs setting their priorities?
There's an annual process, but the programs can also look at those priorities on a quarterly process. They can look at them as often as they want, as far as I can tell from the regs.
Okay, so David, I think we're ready for questions.
Okay, so we are here. We've got 8 minutes left, or probably about 6 minutes left for questions, so we can do that. I see many of you have already started writing questions in. We did not get to all the questions you posed, so please rewrite those questions. I see one that Pat asks is about the regs. Can you address 1626.4C1, the activity giving rise to eligibility violated a law of the U.S. or occurred in the U.S.?
Okay, so there was a policy letter. Is this the one issued? Mm-hmm. Okay, so there's a policy letter that was issued, not this one, Thursday, that describes exactly this issue. I'm trying to get it open in front of me. Robin, if you have it, that would be useful.
I do. And basically, it's Program Letter 1413, and it defines and says that the qualifying activity does not have to have occurred in the United States. For purposes of eligibility for LSC-funded assistance, an activity that violated the law of the United States means an activity that's described in the definition of battered or subjected to extreme cruelty in 1626. Is described in the definition of victim of sexual assault or trafficking in 1626 also, or meets definition of severe forms of trafficking or a crime listed in the U visa section. So
as I understand it, is that essentially, according to the program letter, which is describing essentially the regulation and the approach taken by the statute, that if any of these, remember the list of U visa crimes, criminal activities that BB showed you earlier? If any of those things or a severe form of human trafficking have occurred either in the United States or outside of the United States, then the victim is eligible for legal services representation, provided they meet the presence requirements that are imposed on victims of severe form of human trafficking and VAWA LSC 2005 trafficking.
That's good. And
Okay.
the regs should be read together with this program letter.
Okay. Are there other questions that people have? The chart associated with the 5/19/2014 LCS program later did not come up when you come up with a link. So there was a question about one of the links. So, and post the chart also, so someone will. That I think.
Chart is posted. We'll make sure the link is active.
So we will go ahead and do that. If there's any last questions, this is the moment.
Okay. David, there's another
yes.
question that I see that somebody wanted clarification. Is if you're working with a victim of domestic violence who enters your office, and let's say before they came to you, they've made a police report, and they qualify for an interested in pursuing the or they've just either a police report or they've called 911. They've somehow worked with law enforcement or prosecution. There's a variety of ways to do it. We actually have a tool on helpfulness that we can share with you that's on our website that gives all the different ways people can be helpful to investigate detection, investigation, prosecution, conviction, or sentencing of a criminal case for U visa purposes. If somebody has been a victim, then they don't have to have made the police report yet, and they don't have to have actually, taken all the steps to perfect their U visa before they could be represented. In fact, what this says is if they're a victim, let's say, of domestic violence, sexual assault, human trafficking, or other U visa crime, and domestic violence, sexual assault, human trafficking are the biggest categories of criminal activity that makes up about 75% of the U visa cases filed nationally, that if they're eligible, because this has happened to them, then LSC would be able to represent them. And one of the things that lawyers do often in these cases is help victims who've been unsuccessful or had been afraid to file police reports before to get them filed once the representation starts as part of their U visa case. And some victims may have, particularly those who are limited English proficient, may have tried to make police reports and been unsuccessful because of language access barriers in many parts of the country. And we see that in about 10% of the cases on research that we did between victims of sexual assault, domestic violence, and human trafficking, police reports are not taken even though the victims called for help. And so language access is a big part of that, and the police report doesn't have to be filed before the agency can represent. It could be part of the representation.
Okay.
Other questions?
Are there any other questions? We only have 1 more minute left for questions. As there are so many unaccompanied minors arriving who are abandoned by both parents as a child, I'm wondering whether we can make the argument that alone is extreme cruelty, which would allow us to serve them as DV survivors. I know that's very case specific.
So yes, it's very case. Robin, I'm going to try this and then you can help me.
Okay.
Under the regulations, they have to qualify under anti-abuse, which is battering or extreme cruelty. Whether abandonment is extreme cruelty is very fact-specific, and I'll give you kind of 2 extreme examples to give you an idea of kind of which ways it can go. If a child was abandoned by her father at age 3 and then, was raised by her mother and went through all kinds of hardships because of the abandonment and then ended up here with her mother, she might qualify because the abandonment of a child at age 3 could be extreme cruelty based on the facts of the case. If the child was 16 when their father abandoned them, then that may be a very different fact-specific scenario, and it's not likely that they would qualify just based on abandonment if it happened when the child was older, because it would be harder to characterize that abandonment as extreme cruelty.
I thank you. Someone is asking a question about the police report, and this is the one Rosa is asking about. Some women are told they cannot apply for a U visa without a police report. This is where they should be calling in probably to be getting some support on how to be able to advocate in those circumstances. That's
correct. We provide case-by-case technical assistance on those circumstances, and you don't have to have a police report to file a U visa, but commonly most U visa certifications most of these victims do in fact file police reports at some point, but there may be other ways to do it.
Okay, and Rocio wants to make sure we get this in as our last question. Can you please clarify, can an LSC funded organization represent a victim of battery or extreme cruelty in an asylum case, or only after they apply and receive asylum?
No, if you're being represented under the anti-abuse laws, they can be represented in any kind of immigration case they have that may be related to overcoming and reducing the impact or their healing from abuse. So you could have somebody who actually, they're stronger asylum, they might be a gender-based asylum case because of domestic violence. It might be they have a stronger asylum case on religious persecution that could also be pursued if you can show that immigration remedy is what they need to overcome the physical or sexual assault or the impact of that they've experienced.
Yeah, with this, we are out of time, so I apologize, but I do want to highlight that technical assistance and materials are available. From NewApp, you can call 202-274-4457 or send an email in the email library, and also the National Legal Aid and Defender Association technical assistant Murphy is available and have her information here. So I want to really thank all of you. Thank Robin Murphy. I'd like to thank Denver, and I'd like to thank Leslie Arloff and all of you from NewApp and everyone in the audience for asking such great questions and sharing your knowledge with each other. So I will, any of the guests, if you have any last words as we say goodbye.
No, I just echo your thank yous to Leslie and Benish and you, David, and the audience for participating.
And
thank you all. I think this is a very exciting opportunity, and we look forward to working with all you. And we really thank both the staff at LSC who've gotten these regulations and policy memorandum out, and to, as always, OVW for sponsoring this so that all of the grantees can learn about everything that they can potentially do for immigrant survivors. Thank you very much.
Thank you. In about a half hour, you will receive an evaluation. Please fill that out. Give us more information to help inform future webinars that NewApp will be offering around this topic. With this concludes today's webinar and Legal Services for All, new 2014 Legal Services Corporation Regulations implementing VAWA's 2005 Immigrant Crime Survivors Access to Legal Services. Thank you very much. We will see you in the next NewApp web conference. This concludes today's web conference.